afternoon, everyone, and welcome. My name is Keisha Mahendra from ICEL, and I'll be your MC for today's session. Thank you for joining today's regional webinar, co-organized by ICEL, eLaw, Ariel, and the CLCJ. Exactly 1 year ago, on 23 July 2025, the International Court of Justice delivered its advisory opinion on the obligations of states in respect of climate change, a request that drew participation from a record 98 states and 13 international organizations, and on which court was unanimous on every point. The opinion set a stringent standard of due diligence. States must maintain a functioning national system encompassing legislation, administrative procedures, and an enforcement mechanism all at once, and must exercise adequate vigilance to keep that system running effectively. It also found that discretion under the Paris Agreement is not unlimited, that states owe each other a duty to prevent significant harm to the climate system under customary international law, and that legal consequences may attach where these obligations are breached. That momentum has carried forward at the multilateral level through a UN General Assembly resolution adopted this past May with 141 states in favor. And at the regional level, ASEAN adopted its own complementary instrument, the ASEAN Declaration on the Right to Safe, Clean, Healthy and Sustainable Environment, or ADER. Now moving into an implementation phase through AICHR's development of Regional Plan of Action. But beyond these normative developments, domestic uptake of the advisory opinion across ASEAN member states has been highly uneven, and formal engagement with the opinion doesn't always track substantive alignment with its core findings. That is precisely the gap this webinar was convened to examine. 1 year on, how far has this opinion genuinely shaped policy reform and civil society mobilization across our region, and where do domestic responses converge with or diverge from its core legal findings? Today's sessions bring together civil society, environmental defenders, academics, and policymakers from across ASEAN to take stock of what has been achieved and where the gaps remain. To get us through today's presentation and discussion, I'd now like to hand over the floor to our moderator, Nadia De Mandevina from ICEL. The floor is yours.
Thank you, Keisha, for the kind introduction. Good afternoon, everyone. Good afternoon, our speakers, and to all the participants. Hope you're doing amazing today. Welcome to today's webinar, and thank you all for joining us. Before we begin, I'd like to briefly explain the format of today's session. We will first hear presentations from our four speakers. After all the presentations have concluded, we will open the floor for a Q&A session. Throughout the presentations, please, to all the participants, please feel free to submit your questions using the Q&A feature on on Zoom. It's on the bottom part of the Zoom. And please kindly indicate which speaker your question is intended for. And I will read the questions during the discussion session in the last session. And please keep your questions concise and short. I think that's all. So without further ado, please let's begin with our first speaker. Our first speaker is William Shelter, or BJ. BJ is a public interest environmental lawyer at the Environmental Law Alliance Worldwide, or eLaw. In this role, BJ works with eLaw's law team to support other public interest environmental lawyers through research, training, and collaboration, focusing on the Asia region. BJ began his career supporting communities and NGOs on environmental matters in his home state of New Jersey in the US, before transitioning to focusing on efforts to strengthen environmental governance and rule of law in Asia. BJ, the floor is yours. You have 15 minutes, please.
Okay, thank you. Should be good now. Okay, good afternoon, everybody, and thank you to all the participants for joining. It's nice to see a few familiar names in the attendees, and a big thank you to ICEL for organizing this important webinar to commemorate the 1 year anniversary of the advisory opinion. What I'm hoping to do today is just to provide a sort of, let's see, how do I? Okay. What I'm hoping to do today is provide a quick overview of 6 examples that we found of recent uptake of the ICJ Advisory Opinion in order to sort of help generate some ideas and questions and sort of help frame the discussion later on. So I've selected as you can see on the screen, 3 court decisions that either cite or reference the advisory opinion, as well as 3 legal filings that also cite or reference or depend on the advisory opinion. And I should say this list is by no means exhaustive. There are a lot of other examples out there, but in the interest of time, we'll focus on these 6 for today. But that said, if anyone knows of any interesting cases that they've worked on or have read about or heard about, I would be really interested to hear about them. So without further ado, let's take a visit to Norway. The first case I'll review is Greenpeace Nordic versus Norway. This is a case that was decided by the European Court of Human Rights, and the claim in the case, which worked its way up through the Norwegian court system before getting to the European Court of Human Rights. The claim was essentially that Norway's issuance of licenses for oil and gas exploration was violating the plaintiff's rights to life and rights to private life and family life under the European Convention on Human Rights. So in the case, the court actually ruled or found that there were no violations of human rights, and this was largely because the claim concerned the issuance of licenses for oil and gas exploration, whereas under the Norwegian system, in order to perform any extraction activities, those activities would still be subject to a full environmental impact assessment review. So the plaintiffs in the case, they still would have an opportunity to vindicate their rights in that process. And it's important to note here that the court, the European Court of Human Rights, the plaintiffs did raise claims more generally about Norway's climate laws and policies. However, these were not adjudicated in the underlying case in Norway. So the Court of Human Rights didn't have jurisdiction over those claims and did not review those. So the decision was limited specifically to the issue related to the exploration licenses. However, even though the court found that there were no human rights violations, the court did heavily reference the advisory opinion in reaching its decision and in affirming Norway and all states for that matter, their obligation to conduct environmental impact assessment, including climate change analysis and Scope 3 emissions, as well as affirming states' obligations to ensure meaningful public participation in those processes. So next, we will move over to the Netherlands. This was a case that was decided in the Hague District Court in January of this year. And the claim was that the Dutch government was violating international and domestic law by failing to implement mitigation and adaptation measures adequate to protect the residents of Bonaire, which is an island in the Caribbean, which is part of the Dutch territory. And as such, as an island, was sort of subject to different and more pronounced climate impacts than residents in the Netherlands. And so the court ruled that the residents of Bonaire do face disproportionate climate risks and that the government has failed to take adequate mitigation and adaptation measures to protect them. And one interesting thing about this case in particular was that it was partly based on Article 14 of the European Convention on Human Rights, which prohibits discrimination. So part of their claim was that by failing to take specific measures to protect the residents of Bonaire, the Dutch government was essentially discriminating against them as opposed to, residents of the Netherlands. So in the ruling, the court ordered the Dutch government to adopt greenhouse gas emissions mitigation targets covering the entire economy and to develop a specific adaptation plan for the island of Bonaire. And again, the court heavily referenced the advisory opinion throughout this decision. The court stated that it obviously took the advisory opinion into account in reaching the decision, as well as affirming that all states, and the Netherlands, compliance with international obligations affirmed in the advisory opinion must be assessed on the basis of whether it has exercised due care and made every effort to the best of its ability to take measures to address climate change. So it's another good sort of affirmation of the obligations that were laid out in the advisory opinion. Next, we will move to Canada. This was a decision out of the Ottawa Federal Court, and this one was interesting because it also included claims related to Indigenous people's rights, and the claims were essentially that Canada's failure to adopt adequate policies and laws to address climate change were violating the plaintiffs' rights, including Indigenous people's rights. So the posture of this case was, or this decision was that Canada, the government of Canada had filed a motion to strike the plaintiff's claims because they were, in the government's view, overly broad and non-justiciable. And the court did agree with this. The court granted Canada's motion to strike the claims because they were overbroad. However, the court granted leave to the plaintiffs to amend their complaint to bring a common law tort claim against Canada for violation of customary international law. And so that's a bit of a mouthful, but it's with this case, it's one thing to understand is that Canada is a country where international obligations under things like the UNFCCC and Paris Agreement and the UN Declaration on the Rights of Indigenous Peoples are not automatically incorporated into Canada's legal system without specific legislation doing so, which is not the case for those agreements that I just mentioned. However, Canada does, or customary international law is automatically incorporated into Canada's legal system. And so the court left the door open for the plaintiffs to bring a claim based on violations of customary international law. And in doing so, the court relied heavily on the advisory opinion as influential in terms of understanding customary international law and state obligations. So moving to the Eastern Hemisphere, I guess we looked at a communication filed by 10 Australian citizens to the UN Human Rights Committee under the first optional protocol to the ICCPR. This was just filed a couple of months ago in June. And the plaintiffs asserted that Australia's is essentially based on Australia's production of fossil fuels for exports and alleging that that was violating their rights under the ICCPR. And the communication, you can find it online. It relied heavily on the ICJ advisory opinion in making several arguments, including that Australia must comply with its international climate obligations in order to protect their rights under the Convention on Civil and Political Rights. And Australia must act with stringent due diligence, and a state's failure to mitigate greenhouse gas emissions is conduct attributable to the state that may violate human rights obligations. And finally, that a state's failure to regulate its export of fossil fuels is also conduct that may violate human rights obligations. So like I said, this was just filed 2 months ago. So it will be, this one will be an interesting one to watch to see how the Human Rights Committee responds to this communication. So next, we will take a trip to Korea. So this is a case that was filed in August of last year, so just about a year ago, in the Gwangju District Court in South Korea. This is, I believe, the first climate lawsuit filed in South Korea to demand financial compensation for climate-related damages. The case was filed by a group of 8 farmers against KEPCO and its 5 subsidiaries. And KEPCO and its subsidiaries essentially have a monopoly over the generation, transmission, distribution, and sale of electrical energy in Korea. And as such, you could imagine they produce a large amount of greenhouse gas emissions. So this, like I said, this was filed in August 2025. So this was literally only a few weeks after the ICJ advisory opinion. So the complaint does not heavily cite or rely on the advisory opinion. However, it does, mention it. And the complaint stated that the advisory opinion by the ICJ makes it clear that governments and entities authorized by government have a legal obligation to prevent environmental damage that threatens the lives, dignity, and well-being of people. As far as I could tell, there have not been any decisions yet related to this case. So this will also be an interesting one to watch, especially to set sort of precedent for issuing financial compensation for climate damages. And finally, we'll move from Korea to Malaysia. And this one, likewise, I believe, is the first climate litigation case filed in Malaysia, which is pretty exciting. The case was filed by Rimba Watch in the Kuala Lumpur High Court. And the case in the court was essentially an appeal of the decisions made by 2 separate ministries in Malaysia. So Rimba Watch had filed petitions with both the Trade Ministry and the Environment Ministry. Those are not the official names. But the claim was essentially that the Shell company, was advertising certain, I believe it was engine oil products, as being net zero. And Rimba Watch believed that these claims were false. And in a sort of like almost comical way, the Trade Ministry responded saying, we don't have jurisdiction over this because it's an environmental issue. And the Environment Ministry said, we don't have jurisdiction over this because it's a consumer protection issue. So this sort of revealed a big regulatory gap with regards to these types of claims. And so Rimba Watch brought it to the court. And the complaint, likewise, did rely somewhat on the advisory opinion. And this quote is actually from the press release that Rimba Watch released. But they stated that the advisory opinion establishes that the standard of due diligence required of states in protecting the climate system is stringent and demands that states put in place a national system, including legislation, administrative procedures, and an enforcement mechanism necessary to regulate the activities in question, and exercise adequate vigilance to make such a system function efficiently. I apologize for running through that quickly, but I wanted to stay within my time frame. And like I said, these are just a few quick examples to try to spark some ideas and questions and thoughts for later. And if you have any cases, interesting cases, like I said, I'd be really interested to hear them. And please feel free to email me. And thank you for your attention. And thank you again to ICEL.
Thank you, Vijay, for that great overview. What really stands out is how fast, yeah, the advisory opinion has moved from paper to real courtrooms. The results have been mixed, yeah, and that's actually useful to see. Some claims won and some is dismissed based on technical grounds, but can be refiled. It shows that how a case is framed and argued just as much as legal theory behind it. So now let us move to our next speaker. Thank you again, DJ. So our next speaker is Rocky Guzman. Rocky Guzman is the Director for Law and Policy of the Asian Research Institute for Environmental Law, or ARIL. He is an environmental lawyer and policy specialist with extensive background on oceans and environmental rights. Rocky has worked on issues from fisheries management and plastic pollution to marine conservation and strengthening the rule of environmental law. He was previously the policy campaigner of Oceana in the Philippines and has been involved on marine conservation and ocean governance with the Asian Development Bank, UN Environment Program, and the Sustainable Ocean Alliance. Rocky obtained his law and political science degrees from the University of the Philippines and his Master of Environmental Policy from Duke University. So, Rocky Guzman, please, the floor is yours. You have 15 minutes.
Great. Thank you so much, Dima, for that introduction. Good afternoon, everyone. An honor to be here this afternoon. I will be presenting on the ASEAN context and why the ICJ matters. But before I start, I really want to recognize that 1 year since the ICJ so much has happened within the ASEAN context as well as worldwide. But I also want to recognize that this would not have been possible if not for the work of the youth, as well as Pacific Island nations and frontline defenders who have made this ICJ possible. So first off, I want to focus first on the regional context in ASEAN and why the ICJ matters so much. So because of this development, we can now see that at this juncture, climate change is no longer framed as primarily a policy failure, but really a legal one. Now, this matters in the region so much because we have jurisdictions and countries which have high climate vulnerability. A lot of countries also are experiencing rapid industrialization and pressures for the energy transition. And in general, many countries and as a region, the ASEAN is considered to have underdeveloped regional accountability mechanisms, especially as to climate impacts and those to address environmental harm. Now, with the ICJAO, with this development, it doesn't really impose new obligations on ASEAN's region and ASEAN member states, but it really clarifies that obligations that have already been accepted prior now carry legal consequences. And it removes that legal impact ambiguity and really clarifies that these are, legal failures that have potential accountability mechanisms in place. Now, the ICJAO reinterprets ASEAN's model, which is oftentimes considered as soft, more cooperative, and makes it have more teeth. So in the ASEAN context, this provides a structural shift on how things operate within the climate accountability framework. As many of us know, in the ASEAN, we have this ASEAN way, which is rooted in consensus-based governance and mutual respect for sovereignty. And usually, it rarely compromises on sensitive topics, including sometimes environmental issues. But the ICJAO, as it is, it provides an impetus, it provides the shift that's needed uh, to translate political discretion as well as voluntary measures to legal responsibility and state conduct that would be attributable and would have implications in terms of international responsibility and in terms of due diligence, it turns from voluntary ambition to really standards for due diligence that states have to comply with. And just for context for everyone, there are four themes that the ICJAO provides more emphasis and clarity on. That's really important for ASEAN and overall. This includes having erga omnes obligations that climate considerations uh, is owed to the international community as a whole. And we now have objective standards and thresholds which states must follow to operate within the international framework. And there's also stringent due diligence, especially on regulation of private actors that could cause or have emissions, greenhouse gas emissions, and also systemic integration in aligning national standards with international standards, especially in terms of addressing the climate crisis. So with that context, I would like to go to the ASEAN and what the implications are in terms of the region and the respective jurisdictions within. So first, on the due diligence obligations, the ICJ made it clear that this is an obligation of conduct and not result, and the reframing now is towards implementation. And this can be done through stronger environmental impact assessments and tools to ensure that states comply and private actors comply with due diligence obligations. In ASEAN, the applications include new fossil fuel infrastructure planning and domestic energy policy resource management, among others, including policies such as strategic environmental assessment. The ICJAO also provides the explanation or the clarification that it falls under the no harm, cooperation, and intergenerational equity rule. Now, this includes, really recognizing that greenhouse gas emissions are transboundary in nature, and it also affects not just the current generation, but also future generations as well. And this challenges the current development models in many ASEAN countries, which provide support for fossil fuel development and have weak environmental impact assessment regimes. Now, the third one is on emphasizing and clarifying that states have the responsibility for regulation of private actors. And if states fail to regulate, that would amount to responsibility under international law. And this does away with the defense of fragmentation of private actors and that they interpose usually. So this is very important for many ASEAN jurisdictions because ASEAN economies sometimes anchor on many fossil fuel intensive industries such as palm oil, coal, and energy, in construction, and also in finance and investment. And the last one for ASEAN that the ICJAO really provides a lot of clarification and support for is on the developments on human rights and the right to a healthy environment. And the ICJAO provides a lot of discussion on this by recognizing that the right to a clean, healthy, and sustainable environment is necessary to enjoy the vast range of human rights. And this provides normative basis for governments and also strategic litigation at the national jurisdiction, but also within the regional context in ASEAN, it provides interpretative force to developing ASEAN instruments such as the ASEAN Declaration on the Right to a Safe, Clean, Healthy, and Sustainable Environment, which I'll discuss in a bit. Now, what would be the implications, implications for ASEAN concretely? So this would amount to providing the force to strengthen ASEAN instruments. As I've said, this converts obligations from mostly cooperation, more soft cooperation, more aspirational and cooperative, into expressions of customary international law. And this is important for many frameworks in ASEAN, including the agreement on transboundary haze pollution, for instance. It provides more teeth for the implementation of these international and regional frameworks. This means that failure to regulate may translate now to international responsibility. The second implication would be hardening of many of our laws, hardening in terms of the region. In ASEAN, we could anchor language to embed what they used in the ICJAO, which is the standard use is stringent due diligence, and reference to 1.5 degrees Celsius. So it also mandates the use of best available science, including the IPCC reports, and this could be used in regional frameworks in ASEAN. And another one would be it could empower and national human rights institutions. And in a region where we have around 5 NHRIs across the ASEAN member states, this is quite a good development and important because climate inaction now is clarified as a human rights violation. And as such, state failures to regulate would amount to human rights breaches. And thus, this could enable litigants to resort to quasi-judicial bodies, including NHRI mechanisms that would do away with strict court standing rules, for example. So there is another access to remedy, another avenue where we could look for redress for human rights violations brought about by the climate crisis. So these are some implications for ASEAN. There are many more, but I focus on a few of them. And now I want to focus on um, major development in terms of regional environmental governance in ASEAN, and that is the implementation of the ASEAN Declaration on the Right to a Safe, Clean, Healthy, and Sustainable Environment, and how the ICJAO provides the support and the force to make this a stronger framework for the region. So many of you might know that this was the ASEAN Declaration was issued last year, and now we are in the process of making a regional plan of action that would fill in the details for this declaration. And this includes, procedural elements such as the access to information, public participation, and access to justice, the tools and mechanisms to implement that, as well as substantive, implementing the substantive right to healthy environment. Now, what the ICJAO can do in this process as we go to the regional plan of action is it could provide the necessary legal backing to ensure that we have stronger impact assessment as a tool to implement procedural environmental law. And this includes integrating climate considerations and impact assessment frameworks, including EIA, strategic environment assessment, as well as transboundary and health impact assessments. This could include also cumulative and long-term impacts. Another key theme where the ICJAO could really boost the provisions for is on responsible business conduct, and this includes clarifying how states and the level and standards of how states should regulate companies, and includes the examination of permitting, disclosure requirements, standards, the examination of the supply chain and access to remedies, among others. And lastly, as we go to the regional plan of action, it is important to look also at how we could provide the framework to protect environmental human rights defenders, to address threats such as harassment, criminalization, in many jurisdictions, slap suits or harassment suits, and in some countries, violence and killings as well, which is very rampant. So the RPA, with strong backing from the ICJAO, could provide the legal protections and response mechanisms to ensure that we have protections for environmental defenders. Now, again, as I've said, the ICJAO since last year marked the beginning. It's not the end point. It's the beginning of much advocacy and action happening across the world, including here in the region. And at the start of the year, Ariel, along with partners, convened a symposium to look at how we could implement the ICJ Advisory Opinion on the ground, because this is now the next phase to ensure accountability. And some key priority actions that were identified by civil society that could be forwarded also and could be advocated to policymakers in the region at the national level. It includes integrating climate and health governance discussions, as climate change is a determinant of public health, and there's a need to ensure the integration in public health and planning frameworks. The second would be the translation of the AO in ASEAN regional governance, including, as I've said, in the regional plan of action and implementation of the environmental rights declaration, as well as the post 2025 ASEAN plan for the environment, or ASPEN, as well as the various environmental and human rights instruments that ASEAN is developing right now. The next one would be on stronger environmental impact assessment and reforms within national jurisdictions and providing standards that would comply with the standards set by the ICJ AO, including stringent due diligence. The next one would be on building capacity for everyone, policymakers, for regulators, as well as civil society, the youth, and communities in using the ICJ as a tool for advocacy to ensure climate accountability. So this could include education, and we have, this is a good start to have this conversation going because it's a good tool for the climate accountability. And lastly would be strategic litigation and corporate accountability, and this provides, the ICJAO provides a lot of basis to ensure strategic litigation within national jurisdictions, but also cross-border litigation and claims as well. And this would be a start of a potential litigation across many jurisdictions. Now, that was a quick snapshot of what it means for ASEAN, what the AO means for ASEAN. And again, within 1 year, it has led to so much discussion and so much hope on what's in store for the future and how we could use it for our advocacy. But what could come next for ASEAN? It would really depend. But here are some of the pathways, including first on litigation. Again, there are discussions already among law groups, but there's also a need to look at rules of procedure to ensure that, for example, we could break down barriers for litigation, for instance, including on standing, on causation, and attribution requirements across judicial procedures. And the next one would be on the pathways for policy and governance, including on environmental rights, on tools such as EIA, Strategic Environment Assessment. We already have in the Philippines, for example, discussions on a pending bill on climate accountability. We call it the CLIMA bill, which would provide the framework for due diligence, as well as corporate accountability and potential loss and damage funds that would directly implement the ICJ AO. We could also look at the pathways for health impacts and really building on that. And lastly, on enhancing regional cooperation within ASEAN, but also South-South cooperation, including in the Pacific, from which this initiative was born out of. So we also have the symposium statement here. You can check what would be the next steps that have been identified, and we'll be really happy to garner more momentum towards the implementation for the ICJAO. Now, I'd like to end here by emphasizing that the ICJAO in itself is not a silver bullet that would solve the entirety of the climate crisis. But what it does is it provides and removes the legal ambiguity that has been shrouding this discussion and provides, the clarity to implement the climate change considerations and these legal requirements across jurisdictions. And now the time is for ASEAN governments, national jurisdictions, courts, lawyers, and institutions to operationalize the ICJAO. And it's now the time to translate the advisory opinion into action. So again, I'm happy to take more questions later on, but thank you very much for this opportunity.
Thank you so much, Rocky, for the insight and for laying out just how significant this shift is for ASEAN. Yeah, I think there are at least two important points. Firstly, the core point we would like to underline is the AO of ICJ doesn't create new obligations for ASEAN states, but it clarifies the obligations they already have accepted, now carry real legal consequences, or as Rocky said, legal clarity. right? And the second one is we also heard concrete entry points. Thank you, Rocky, for where this plays out in practice through, let's say, stronger environmental impact assessment and strategic environmental assessment processes that accounts for cumulative and long-term climate impacts, protection for environmental defenders, and closer scrutiny of how states regulate private sectors. The Philippines Climate Bill, for example, shows this translation from legal opinion to legislative action is already underway in ASEAN region. Thank you once again, Rocky. Next, we will zoom in into how this AO of ICJ has had an impact on Indonesia's policy reform and legal action. So our next speaker is Evan. Zevanya Albrena Sembiring is a junior lecturer at Faculty of Law, Universitas Indonesia, and researcher at Center for Environmental Law and Climate Justice, or CLCJ. He was educated in Indonesia, Universitas Indonesia for Bachelor of Law, and in the Netherlands, Universiteit Utrecht for European Law, with concentration on law and sustainability. He possesses specialty areas encompassing topics Indonesian environmental law, EU environmental law, climate law and governance, climate litigation, intergenerational rights, and the legal framework of emerging climate engineering techniques such as carbon dioxide removal or CDR. Apart from his works in publications, Zevanya has also devoted himself in several research projects contributing to the legal scholarship in Indonesia. He participated in projects initiated by international and national organizations. So, Zevanya, the floor is yours. You have 15 minutes.
Thank you, Nadia, for your kind introduction. So, good afternoon, everyone. It is an honor to have this opportunity to share with you my presentation regarding Indonesia's context, especially after the advisory opinion, and more specifically, I think after the UN General Assembly resolutions. So I would like to begin my presentation by, I think, highlighting the context of Indonesia because the previous speaker, especially Rocky, has said that, and also, of course, BJ has mentioned about how the advisory opinion has impacted several jurisdictions and how it is being replicated in many cases. But when it comes to Indonesia, I think there are no formal actions has been taken from by the government, and we haven't really seen quite a lot of cases that try to use the takeaways from advisory opinion in concrete cases. So to begin, I will. Oh, those my slides. Okay.
Rarik, can you please share? Thank you.
Okay. Okay. Can you move to next slide, please? So here is my I think agenda for today's presentation. So I will share about some relevant takeaways from the advisory opinion and Indonesia, how Indonesia respond to the advisory opinion. And the second one is about the regulatory gaps that I spotted that perhaps can be a useful way to scrutinize how Indonesia should improve and how Indonesia should increase the commitments after the official opinion. And I will share about some new strategies, of course, deriving from the official opinion takeaways. And lastly, I will share some outlook of Indonesia's climate law after the official opinion. Next slide, please. Next slide. So perhaps I think this is, of course, not an exhaustive list of how the advisory opinion clarify legal obligations or state obligations. But I think these four findings will be really relevant and important for Indonesia because as we are now entering to the second NDC era, I think some of these takeaways will be really, really important. So the first is I think the 1.5 degrees temperature goal is now to be the parties agreed primary temperature, and I think this will be important to see how Indonesia should actually evaluate and also try to scale up the NDC, of course, based on the best available science. And the second one is there is a ceiling actually in preparing NDC because, as I will mention in the next slide, Indonesia still agree that there is a flexibility in preparing the NDC. But I think it's responding to that. I think the advisory opinion will be really important to reply to that sort of notion coming from the government, especially in the written statement that is brought to the advisory opinion proceeding in the Hague. And the third one is highest possible ambition as reflected in NDC must be backed up with adequate domestic measures to achieve the NDC. This is really really important to see how ambitious our NDC. And the last one, I think it is also relevant to Indonesia, especially when we talk about the fossil fuel phase out agenda. So I think these four takeaways will be really interesting to will be interesting to be I think to be a focal point when we talk about Indonesia's context. Okay, so next slide, please. So before we talk about and I will try to assess some regulatory gaps that I think quite relevant to us. I would like to take us to see the Indonesia's responses throughout and after the advisory opinion. So first of all, Indonesia written statement when when the advisory opinion when the court invited several countries to give their statement. I am of the opinion that Indonesia's responses is quite underwhelming and it was quite formalistic. Why is that? It's quite simple. I think there are three reasons. The first is because the statement from Indonesia did not recognize other international law regime to constitute obligation on climate change. So it's quite clear in the paragraph 45 and paragraph 61 that Indonesia argue that state obligations on climate change only come from the international climate regime. And the statement clearly stated that it did not recognize other international law regime, including the international human rights regime. So it's quite astonishing to see because when if you observe the statement, there is no clear reference for this claim. So this is the first one. And the second one, Indonesia did not acknowledge customary international law to have any place to take part in clarifying state obligations. Therefore, actually, it's quite contradictory to what the court finally clarified. And what is more shocking to me is because one of the statement clearly states that prevention and precautionary principle doesn't belong to in customary international law. So that is what is being written in the statement. So it's quite shocking to me. And the last one, I think the Indonesia's statement said that it used CBDRRC or Common but Differentiated Responsibility and Respective Capabilities principle as a license for inactions. Actually, in the statement, there are a lot of arguments being brought to say that CBDRs should be should take a center stage when we talk about state obligations. So, and in the end, the Indonesia statement clearly stated that it should view CBDRC to be the principle to guide the obligations of especially Indonesia in the advisory opinion. So, but notwithstanding the disappointing statement, in my opinion at least, Indonesia still accepted the adoption of UNGA resolution back in May this year. So even though there are a lot of underwhelming and formalistic statements, Indonesia still adopted the UNGA resolutions, which means this authoritative clarifications on existing international climate obligations must also must be also applicable to Indonesia. Apart from the adoption, I think no formal action has been taken by the government, even though we witness a introduction of new presidential regulations. I think there is no clear correlation between the advisory opinion and the newly enacted law on climate change. Next slide, please. Next slide. So the gap that I would like to share first is the NDC, of course. So there is a change from the enhanced NDC that we have in that Indonesia has in 2022. So Indonesia now transition from the business as usual method to reference year, as 2019 is now the best year to calculate the greenhouse gas emissions now here in Indonesia. But the question is still remains, I think, is it in line with the 1.5 degrees? Because I think when we talk about the official opinion, it's already clear that now the primary temperature goal should be 1.5 degree. And the second one that I would like to invite us to reflect is that does it really represent progression and highest possible ambition? Because as you see here, we have three scenarios that the government introduced. However, if you see here, the emissions will still rise, at least in the first scenario, will still rise until 2050. So after 2050, then we will have a decrease of greenhouse gas emissions overall. So for me, this is quite. I'm quite pessimistic because if we see a report, next slide, please, from Climate Action Tracker, and this is just being published after the introduction of second NDC, we're still in a really critically insufficient condition, and this is because I'm still trying to understand the science here because there are a lot of technical terminologies that I need to comprehend. But I think it's because we haven't really introduced a calculations of NDC that also include historical emissions, and because of that, we are still in really a critically insufficient condition. And I think this will be not in line with what we understand as highest possible ambitions understood in the advisory opinion. Next slide, please. So when it comes to the implementation as well, Indonesia will still accelerate the offset market rather than accelerating deep reduction schemes, And this also becomes one of the problem when we talk about the emissions trading that we have now here in Indonesia, because emission trading has not been functioning effectively has not been functioning effectively recently because of two reasons at least. Because there is a failure to create scarcity when we talk about emission trading. Is really important to have a scarcity to incentivize the actors. The second one is because of a conceptual error, because emissions trading and tax applied at the same time, and this has been going on since 2022, and there is no clear responses from the government to really fix this conceptual error. So I would say this is really low implementation of domestic measures to achieve the NDCs. And the second one, and the third one is in the presidential regulation that the Indonesia's government introduced in 2025. For me, it failed to elevate the domestic measures as well, because I take just one example out of it, because the introduction of carbon budget uh, or allocation carbon to guide the NDC preparations is now being in place. We have this. We have a new procedure to establish the NDC. However, if we take a deeper look at the carbon budget understood in the regulation, it actually not it deviates from the carbon budget known in the IPCC report. So for me, it is quite a big gap, because it means that our NDC will not be based on the best available science, which in this case I believe is the IPCC report. Next slide, please. So I think I will not, because I have quite a limited time, so I will just move to the last slide, please. I will, next. Yes, next, please. Next slide. So I think I will just conclude my presentation with some of this outlook of Indonesia climate law. So for me, after the advisory opinion, because of Indonesia have quite relied heavily on CBDRC to evade the obligation, I think after the advisory opinion, Indonesia cannot use the same argument now, because of course we still recognize CBDRC to be the guiding principle, but now we have a new interpretation, and the advisory opinion played a significant role in that, because now the differentiation for me is through due diligence. And the second one is about robust science. So we now we need to really scrutinize the science that we use to be the basis of the NDC, because the carbon budget that I mentioned earlier is not really in line with the current budget understood in the IPCC report, and is not based on the best available science. And the third one is domestic measures are in urgent need for reformation. So we need to really limiting the offsets, because it is not really incentivizing a lot of the private actors to 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 do the trading in the emissions trading scheme, and of course restructure the emission trading to invite more sectors to also participate in the emissions trading. And I think the last one that I uh, like to perhaps invite us to reflect is about the fossil fuel phase out, because in the advisory opinion, even though the court has not really taken a lot of time to clarify the fossil fuel phase out obligations. But I think a joint declaration from Judge Bandari and also Cleveland at least clarify that by saying that to fossil fuel phase out obligations also will oblige the state to assess the scope 3 emissions in the environmental impact assessment. So I think there are there are a lot of takeaways that really interesting to discuss. And I think Indonesia's experience is quite interesting because we haven't really seen any formal action taken by the government. So I think the civil organization and also academics must take actions in the future. So I think that is from my end. Thank you very much for your time.
Thank you very much, Zevanya. Thank you for that very detailed assessment. So, firstly, a key point was raised by Zevanya about the contrast between Indonesia's formal position and its statement during the AO proceedings. So, Indonesia accepted the UN resolution, but during the proceedings, it did not recognize certain international law and reference CBDRRC in relation to its approach. And also, thank you, Zevanya, for highlighting several data points, including questions about whether Indonesia's NDC baseline aligns with 1.5 degree pathway, structural issues within the emissions trading scheme, and continued fossil fuel reliance projected to rise toward 2060. And thank you also, Zevanya, also for outlining potential litigation approaches, including testing Indonesia's NDC against due diligence criteria, reviewing fossil fuel-related licensing frameworks, and incorporating Scope 3 emissions into EIA documents. Thank you again, Zevanya. Then for our last speaker, we will focus on the ways forward. So please, our next speaker is Safanah Reski Azahra. Safanah is a researcher and head of the Climate Justice and Decarbonization Division at the Indonesian Center for Environmental Law, ICEL. Her work focuses on climate governance, climate diplomacy, environmental human rights, and just energy transition. At ICEL, she leads and contributes to legal and policy research, provides expert input on climate and energy transition policies, supports Indonesia's engagement in international climate processes, and works on the development of climate-related legislation, including the Climate Justice Bill. She obtained her law degrees from the Faculty of Law, Universitas Indonesia. Safanah, the floor is yours. You have 15 minutes.
Okay, thank you so much, Marima. Okay, good afternoon, everyone. Thank you very much for coming to this webinar. It's a pleasure to be here and to share some reflections on what has happened in the years since the International Court of Justice delivered its advisory opinion on climate change, especially in Indonesia. So rather than discussing the opinion itself, I'd like to focus on a different question. So what do we actually do after the advisory opinion? So over the past years, we've seen growing recognitions of the opinion internationally, but recognition alone is not enough. So the real challenge is translating those legal findings into domestic laws, litigation strategies, and diplomatic positions. So today, I'll briefly share ICEL's experience over the past year, some lessons we've learned, and where we think ASEAN and Indonesia should go from here, especially as we prepare for COP31. Next slide, please. Okay. So a quick word on where the advisory opinion has gone in our work. So how ICEL have approached the opinion through four connected tracks. So the first track is the legislation. So through ARUCI, ARUCI is the civil society coalition who pushes for the climate justice bill. We try to translate the code's due diligence standards into actual legislative proposal. So instead of treating due diligence as an abstract legal principle, we try to turn it into concrete provisions on climate ambition, enforcement mechanism, and also the meaningful public participation. The second track is the litigation. The opinion has become part of our legal strategy, most recently through the Amici Curiae brief that we have submitted together with the E-Law and CLCG FOE in the challenge against Indonesia's fossil-heavy electricity plant. Third is the diplomacy. So where the advisory opinion has feed for Indonesia's second nationally determined contribution, our work on just transition, and our engagement in preparations for COP31. And finally, academics. So we have integrated the advisory opinion, the UNGA resolution, and broader developments in international climate law into workshop for Indonesian law lecturers, helping ensure these developments actually become part of legal education as well. So when I talk what has worked and what hasn't, it reflects lesson drawn across all these four pillars. Next slide, please. Okay, so the climate justice bill. Let me begin with legislation. So one point needs to be made clearly is that the climate bill currently sitting in parliament is still heavily focuses on carbon market regulation. While carbon markets certainly have a role, climate governance requires much more than that. So Aruki, the coalition that I've mentioned before, pushes more on highlighting the just aspects of climate change. So Aruki's proposal takes a different approach, grounded directly in the court's findings. So the advisory opinion tells us that the climate governance is ultimately about due diligence. States must adopt measures capable of preventing harm, regulating emissions, protecting vulnerable communities, and also ensuring meaningful participation. That means Indonesia needs a framework law that goes beyond creating market mechanism. It needs binding obligations, enforceable sanctions, and guaranteed public participation throughout the climate decision making. So earlier this year, the parliamentary bill progressed further than any standalone climate law has before. Its harmonization process was temporarily suspended because there was a proposal to merge it into the revision of Indonesia's environmental protection law. But today, the merger proposal appears to have lost its momentum, and the standalone bill is still expected to continue. So the question has changed. It is no longer about whether Indonesia will have a climate law. It is the question whether the law will actually incorporate the due diligence sanctions and genuine participation standards established by the court. So next. Okay, so I'm going to talk about what has worked. So, what has worked over the past year is that the biggest success is that the language of climate justice has finally entered the policy conversation. So Indonesia's new minister of for environment has openly embraced climate justice as the guiding framework for the bill and acknowledged the contribution of civil society in developing that approach. So for those of us who spent the past years translating the advisory opinion into legislative language, this is such a very encouraging signal. So another important lesson is that the value of the coalition building. So, as I've mentioned before, Aruki brought together environmental organizations, academics, legal experts, and civil society under one shared legal demand, which is to push for a climate change bill that emphasizes on the aspect of just. So that collective efforts gave the advisory opinion far greater political influence than any single organization could have achieved alone. Finally, the opinion has also begun influencing the litigation. And the advisory opinion is doing work in court. The civil society invoked it in the challenge to the fossil heavy national electricity plan, and it runs through our MEG Korea brief on planning and permitting. So even where legal outcomes remain uncertain, the advisory opinion has already started shaping legal arguments. Next, please. Now let me turn to what has not worked. There are actually three main challenges. So the first is reviewability. In the challenge against Indonesia's fossil heavy electricity plan, the administrative court dismissed the case before it even reached the substance of the climate arguments. The court held that the electricity plan itself was not a reviewable administrative decision, which means that the biggest obstacle is often procedural rather than substantive. The challenge is not whether the legal arguments are strong enough, it is whether the plans and policies can even be refused by the courts in the first place. The second challenge is also the regulatory gaps. So, since the advisory opinion, Indonesia has made progress in carbon market regulations, particularly in the forestry and land use sector. But critical elements identified by the court, such as the climate ambition, prevention, accountability, and enforcement, still lack a comprehensive statutory foundation. And finally, there is the corporate responsibility gap. The court clearly stated that states have an obligation to regulate major emitters within their jurisdiction, yet we still have no domestic framework requiring corporate climate due diligence or even climate responsibility. Meanwhile, the captive coal continues expanding to critical mineral processing. So ironically, the global energy transition itself is contributing to new coal development in Indonesia without actually corresponding to climate safeguards. Of all the court's findings, this actually remains one of the areas where implementation has been the weakest. Next, please. Okay. So this actually brings us into the international level. So COP31 in Antalya will focus on implementation, finance, and just transition. Fortunately for ASEAN enters this discussion from a relatively strong position. Several ASEAN countries played an important roles in supporting the UNGA resolution requesting for the advisory opinion. So the Philippines and Singapore actually helped to steer the resolution. Cambodia endorsed it and Indonesia voted in favor. Now the question is how to build on that momentum. So I see there are like three opportunities. First is the just transition mechanism. As negotiations move forward, the advisory opinions emphasize on human rights, public participation, and protection of vulnerable communities that should become part of its institutional design from the very first beginning. Second, the UNGA resolution requires the Secretary General to consult member states in preparing the follow-up report. Paragraph 10 requires the report to work in coordination with the UNFCCC and the Paris Agreement without prejudice to any state's legal position. The resolution tells the Secretary General to consult member states. So the ask is simply that ASEAN uses the channel and uses it together. So this creates an opportunity for ASEAN countries to provide coordinated regional input before the report is actually finalized. And third, civil society across the region should continue advocating for explicit recognition of the AOICJ within the COP31 outcomes. 1 year ago, this would have seemed too ambitious, but today, after the overwhelming support shown in the General Assembly, I feel like this is a much more realistic objective. Next, please. Okay. So in the ASEAN context, what should ASEAN actually advocate for? I would summarize it in one word. It is the consistency. So the position ASEAN countries take during negotiations should reflect the position they have already taken in New York, where the advisory opinion confirmed that climate finance, technology transfer, and international support are legal obligations of developed countries. They are not acts of generosity. ASEAN should therefore approach this negotiation from a position of legal consistency rather than creating climate finance as something that must constantly be renegotiated. So a unified regional voice will carry. I feel like the unified regional voice will carry much greater influence than just fragmented national positions. Next, next, please. Okay. Now I will jump to the role of civil societies and what to push domestically. So of course, the international diplomacy must also be matched by a strong domestic implementation. There are three areas where civil society can make particularly important contributions. The first is the upcoming NDC update. Rather than simply increasing numerical targets, the updated NDC should clearly explain how these domestic policies respond to the outcomes of the first global stock take and how they reflect the due diligence principle articulated by the advisory opinion. Second, we need to systematically assess where laws and policies still fall short of the code's standards. That means comparing existing legislation, adaptation planning, and climate governance frameworks against the obligations identified by the court, and identifying concrete legal reforms to close those gaps. Finally, civil society has an important role in supporting countries' position in these two major COP31 negotiations, the design of the just transition mechanism and the launch of the second global stockage cycle. Next, please. So this is a more practical example. So in the context of Indonesia, Indonesia could strengthen its NDC by including a dedicated section explaining how the document responds to both the first global stocktake and the ICJ advisory opinion. This would this would really improve the transparency and the accountability of the NDC. And we can see how Australia have implemented this. So Australia has already provided one useful example by including its annex and explain how each of the GST1 mitigation outcomes is reflected in domestic policies. And Vanuatu has also gone even further by committing to assess government policies against the due diligence standards reflected in the advisory opinion. So countries like Indonesia actually does not need to copy either approach exactly the same. But both example, the Vanuatu and Australia, demonstrate that international legal development can be translated into practical domestic policies commitments. Next, please. Okay. So beyond the NDC itself, the advisory opinion should become part of everyday government decision making. One of the court's key message is that risk and impact assessment are not optional. They are part of the state's due diligence obligations. Fortunately, Indonesia already has many planning instruments that can operationalize this principle. But the climate considerations can actually be integrated into the strategic environmental impact assessment and also the national planning documents and also the permitting processes, which means that assessing climate risk earlier considering the greenhouse gas emissions more comprehensively, including the scope 1, scope 2, and where appropriate, scope 3 emissions, and ensuring that the just transition considerations are embedded throughout planning and project approval. Ultimately, the due diligence should become a whole of government approach rather than a single environmental requirement. Next, please. So finally, let me close by highlighting two tracks where countries, in this case Indonesia, the position can be sharpened at the COP31. So the first off is the just transition mechanisms. Here, the foundation is already clear. The advisory opinion recognized that climate action must respect human rights, and this aligns closely with the decent work language in the just transition work program itself. What ASEAN brings to these negotiations is the lived experience of coal-dependent communities and the insistence that financing should be grant-based because a just transition funded by new debt simply isn't just. And the second track is the global stocktake. GST2 will formally begin at the COP31, which means this is the moment to actually shape the process from the very beginning. The priority should be to ensure that the just transition experience, socioeconomic dimensions, and the meaningful participations of indigenous people and local communities are actually reflected from this first stage onward. Actually, none of this is new. So the court recognized that the rights of women, children, and indigenous people and the UNGA resolution that Indonesia voted for calls exactly for this kind of participation. We're not actually asking for something new. We are only asking that what has already been agreed is reflected where it matters the most in the negotiations themselves. Okay, next. So sorry, I think there's a problem with my slides, but anyway, that was already my closing. So to conclude, my presentation for today, I don't think the question today is whether the advisory opinion matters. It already does. This has been shown by our previous speakers who will talk a lot about how the countries optimize the AOICA. But the more important questions is whether we are willing to translate it into domestic legislation, stronger institutions, more effective litigations, and importantly, more ambitious international diplomacy. So 1 year on, we've seen meaningful process, but we've also seen that legal recognition alone does not automatically produce implementations, just like what Evan has mentioned before. That work still depends on like the governments, courts, civil society, academics, and all of us to actually work together. And I think that's all for me. Thank you very much, and I look forward to our discussion. Thank you.
Thank you very much, Savannah, for that very comprehensive close. So ICEL's all tracks on legislation, litigation, diplomacy, academia showed us that what operationalizing the AO actually looks like in practice, yeah? Looking ahead, Savannah laid out a clear path to COP31, consistent ASEAN positioning, building on the UNGA vote, pushing AO standards into the just transition mechanism, and using NDC updates to formally embed due diligence, following examples like Vanuatu and Australia. So thank you again for all four speakers for the insightful presentation. We will now move to the Q&A session. We have received several questions from the audience. Maybe for this first round, we will focus on the three questions. I will copy and paste it to host and panelists. So the first question is to all speakers. Since domestic laws are not adequate to follow the ICJ's advice, is it possible for an international monitoring court of justice with a permanent monitoring committee to make the individual responsible entrusted with duty? That is the first question to all the speakers. And the second question is to Rocky. Maybe you have answered it in the chat box, but maybe you want to elaborate, feel free. So the question is, Klimabil's due diligence standard of care is do no harm and not stringent. And the last question is to Zefania. You have also answered it on the chat box, but maybe you want to elaborate. Please feel free. The question is, can you please refer in which paragraph of Indonesian statement that mentioned CBDR-RC as a reason for inaction? So that's the three questions for the first round. The floor is yours. Maybe we will start from BJ, maybe?
Sure. I guess I'll try briefly give a response to the question about the International Monitoring Court of Justice with a permanent committee to make, I guess, to monitor implementation. I just practically speaking, I would not hold out a lot of hope for such a international court. I mean, in order to implement something like that, you'd be, dealing with issues of sovereignty, and this is, we're here discussing an opinion from the International Court of Justice, which can only issue, well, at least in a matter like this, can only issue advisory opinions. So, there could be, maybe some kind of mechanism which would be under, an agreement like the UNFCCC to monitor country, progress with regards to implementing the obligations in the advisory opinion. But I just, as a practical matter, I wouldn't hold out a lot of hope for a permanent international court that had sort of monitoring and enforcement powers. Happy to hand it over to other panelists if you, Rocky or Savannah or Zafania, if you have any thoughts on that.
Please, thank you, Vijay. Maybe Rocky first, and also the second question.
Yep. Thank you, Dima. Vijay, sure. Just to answer that quickly, I do agree and have the same sentiment as PJ that it might be, difficult as well because the advisory opinion in itself is not, it's not formally binding, so to speak. And it's while it provides, it carries significant legal weight. It's in an authoritative legal reference. It's not, strictly legally binding, so it will be hard to emanate from the ICJ AO itself. And especially on the context of climate change and fossil fuels, we have had experience, especially like with the negotiations, the UNFCCC Paris agreements, where we do have, entities and bodies, compliance committees, but these are not punitive, not adversarial, more on facilitative. So it doesn't, provide the teeth that's required to implement and measure compliance of state obligations. So that's one. And then also, if there would be a body or a monitoring, entity that would require, potentially another agreement at the consent of states that to have to measure compliance of their compliance. So that would be a totally different ballgame. So the other pathway really is, to independently make compliance standards and measure compliance, and that would be at the national level. So that states, we could measure state compliance at the national level to their obligations as elaborated upon the ICJAO, and that's where the civil society really comes in place, and for advocacy for national governments to do that. So that's the first one quickly. And the second one, the question was on the due diligence standard in the climate accountability bill that's pending now in the Philippines. And again, I reference here that it was, filed prior to the ICJAO developments, and the reference there was more on the no harm principle, as well as that they will conduct due diligence, but not specifying what standard it would be. Um, Now with the clarification and the the very robust explanation of the ICJ on what it entails for stringent due diligence to be implemented by states. Now is the opportunity to fill in the details, and to align that with the standards set out by the ICJAO. So now at the working group level, with the bill pending, now's the opportunity also to clarify on what stringent due diligence might mean to make sure that it aligns with the international standard. So yeah, I'll stop there.
Thank you, Rocky. Maybe next, Zevanya, you want to answer, and also maybe you would like to elaborate on the third question too.
Yeah, thank you. So I think I agree with BJ and Rocky, and because the fifth opinion is not a legally binding instruments that will have a lot of impact. But as I said, there is a um, UNGA resolution that I think would be really important to follow, because uh, even though you cannot have the monitoring court, I mean, International Monitoring Court of Justice to monitor the states to in implementing the obligations enshrined in the official opinion, but at least after the adoption of the UNGA resolution, I think there's a clear statement that advisory opinion is a authoritative uh, legal clarification of international of existing international law. So I think that is really important that a lot of states accept that, which means there is a possibility of causing some new strategies to enforce the states in order in order to really implement some of the obligations uh, 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 introduced by the court. So I think instead of relying on the court, I think now we can also use this UNGA resolution as a new battleground for future advocacy. And another question is about the CBDRRC. My statement about CBDRRC as a reason for inaction, yeah, is not actually explicit in the written statement, but actually, if you take a look at the paragraph from paragraph 65 until 71, you can see that there are a lot of elaboration regarding CBDRRC, and I think the I think one statement that can that indicates that indicates my claim is at paragraph 70. This is the first statement that you can refer to. The statement uh, the statement says that acknowledging the different contributions and capabilities of state in relation to climate change and flexibility in its implementation. And this is the Indonesia's view on the principle of CBDRC, because CBDRC is regarded as the key principle. And after that, you can also see here in this paragraph 71 that Indonesia clearly says that the recognition of the principle of equity is particularly crucial for developing state like Indonesia, and to achieve the ultimate objective of sustainable development, namely poverty eradication. Because of that, you can clearly see that we can at least conclude that at the moment the ultimate objective of Indonesia is poverty eradication, which, in my opinion, when we observe the advisory opinion, uh, this is not really in line. So because of that, I think, and perhaps I also cited Margareta Webring-Kessing and also Viñuales that gave in their newly published article. It states that uh, there are several countries that use CBRRC as a license for inaction. I think in the future, after the official opinion, you cannot use the same argumentation. Now, I think after the official opinion, it's really interesting to see how the developing country will respond to this, because now, for me, the due diligence should be the guiding principle for developing countries in preparing their NDC, and one of that is to achieve the highest possible ambitions, even though we still, of course, see the respective capabilities and also national circumstances. And I think because of that, it's really interesting to see the future efficacy after this official opinion on CBRRC. I think that is from my side. Thank you.
Thank you, Zevanya. Maybe next, Savannah, would you like to add?
Okay, I would like to add just a little bit. I agree with everyone that I think under the current international legal framework, creating an international monitoring court with the power to hold individual government officials directly accountable would be really difficult. So the ICJ advisory opinion clearly clarifies the state's obligations, not like the individual criminal responsibility. So the international environmental and climate law is still primarily based on state responsibility, meaning that states, not the individual public officials, are the subjects to these obligations. That being said, I think the advisory opinion does reinforce the expectations that that states establish effective domestic systems to actually fulfill their climate obligations. This means that the accountability should first be strengthened at the national level through stronger institution, independent oversights, judicial review, and effective enforcement. As for an international monitoring mechanism, I feel like there is definitely a room to strengthen international oversight. Like, for example, the enhanced reporting, peer review, export monitoring bodies, or even like compliance committees under existing international frameworks may be more realistic in the near term, rather than like creating an entirely new international courts. The recent UNGA resolution requesting a Secretary General's report on pathways to advanced compliance also reflects the growing interest in strengthening implementations, although it does not establish a new judicial or monitoring body. I think that's for me.
Thank you all speakers for the first round. Maybe the second round is the last round. I will copy and paste the three questions in the chat box to all the hosts and panelists. Wait. Okay. So for the second round, this is to all the speakers. Maybe you can answer all the three questions consecutively. So the first question is, the Indonesian delegation faced significant criticism during COP30 for including dozens of fossil fuels lobbyists in its official team, demonstrating a lack of ambition regarding the phase out of fossil fuels and pursuing a diplomatic approach perceived as favoring market and business interests over concrete climate action? What are the prospects for COP31, and have current policies strayed from the primary objective of the NDC and NZE? That's the first question. And the second question is, besides the domestic governance and policy gaps, what are other key challenges to translating the ICJAO into climate action? And the last question, there is an increasing number of trade agreements on critical minerals. Can the ICJAO influence the implementation of such agreements? Okay, for all the speakers, that is your questions. Maybe who want to start first? We have BJ on the first round. Maybe Safa, you want to add first?
Okay, I'll try to answer all the three questions. So for the first question, whether the Indonesian delegations in the COP31, so I feel like that the COP31 presents both a challenge and an opportunity for Indonesia. It is actually true that Indonesia has faced quite the criticism in previous COP regarding the compositions of its delegations and the perception that its climate diplomacy has emphasized on the carbon markets and investment mechanisms more than like the emissions reduction. But from a legal perspective, however, I feel like the more important question is to whether Indonesia's domestic policies are actually consistent with the standards clarified by the ICJ Advisory Opinion. So the court made clear that the states must exercise stringent due diligence and adopt domestic measures capable of achieving their climate commitments. In other words, the ambition is not measured only by the targets contained in an NDC, but also by whether domestic laws and policies are genuinely capable of delivering those targets. Looking at Indonesia today, there are still several areas where stronger alignment is needed. But from our presentation, for example, like the continued expansion of carbon market regulations without an equivalent strengthening of due diligence obligations, accountability mechanism, corporate climate responsibility, or even like the comprehensive regulations of fossil fuel dependence, these are like the areas where where like legal reform is still necessary upward. As for the second question, it was about the how besides the domestic governance, the key challenges to translating the ICJO. I feel like there are three key challenges. First, obviously, is the political will. The advisory opinion it provides legal clarity, but like the implementation still obviously depends on government translating those obligations into concrete actions. Second off, I think is the institutional capacity. So many countries like Indonesia, they still lacks the technical, financial, and also like the institutional resources to fully implement the due diligence obligations. And lastly, I feel like one of the most important thing is the international cooperations. So the AO reaffirmed that developed countries have obligations regarding finance, technology transfer, and capacity building. So without this adequate international support, I feel like many developing countries like Indonesia will definitely face significant challenges in implementing these ambitious climate actions. I think that's for me for the second question, those three main key challenges. And lastly, increasing number of trade agreements on critical minerals. Okay. Um, in this case, I feel like the the ICJ advisory opinion, I believe it can, because the advisory opinion makes clear that the states again have duty to exercise the stringent due diligence when regulating activities that may contribute to climate change. So I think with that obligations, it does not disappear simply because like an activity is promoted through trade or investment agreements. So I believe the ICJ advisory opinion can have influence in in the due diligence. I think that's it from me.
Thank you, Safa. Maybe next, Zevanya, you want to answer next?
Yeah, I think I will answer the question on prospects or COP3 and current policies straight from the primary objective of NDC. I think after the ICJ official opinion, it will be interesting to see how countries will argue about the temperature goal, because now 1.5 is a clear primary goal, which therefore for me it should not be a question anymore that some countries will come with that will come with the with policies that will not be in line with the 1.5. I think an example from Indonesia is can be used here, because if we take a look at the Indonesia's NDC, even though we changed the method to base year, we have set 2019 as our reference year. However, it's not really significant because we will still witness a rising of emissions until 2050. And for me, that is a big question mark, because in terms of the science at the moment, uh, we are assessed by the climate action tracker with critically insufficient at the moment. So I think there is um, a problem in how we actually prepare the NDCs, and I think that should be our focal point in the future, especially for Indonesia's CSO to really to scrutinize how we prepare the NDC. And I think another prospects for COP 31, if I would like to if I would like to comment on Indonesia, I think it is also important to scrutinized how we actually now give a lot of captive power plants. We have a lot of regulations on the table that clearly states that some industrial area can have a leeway to install more captive power plants. Especially, it is all coal-fired power plants. So I think with this regulations are in place and that are now in applications, I think it is really interesting to see whether it is in line with the due diligence standard, whether we are really whether we really set up our energy transition in line with in line with the highest possible ambition, because we still have a lot of emissions from energy, and it will only reach its peak at 2050 without a clear pathway and how really we want to phase out this. And I think one of the biggest concerns is because we still have a lot of regulated framework that supports this kind of policies. So I think it would be really interesting to see that. And the I think for the question on ICJ official opinion influence on implementation of such agreements, especially on trade agreements, I think uh, I'm not really in position to answer all of this because I haven't done really a lot of research on this. I think perhaps I will pass it to the other speakers. Thank you.
Thank you, Zevanya. Next, maybe Rocky, you would like to add?
Yeah, sure. Thanks, Timo. Briefly, in the rest of time, I'll just address maybe a couple of questions. First, on the domestic, besides the domestic and governance and policy gaps, what would be the key challenge? And this is coming from Attorney Jordi, is a litigator, and so I would like to focus more on the litigation side on this. For one, there is, appetite to have more, cases on domestic cases as well as cross-border cases on implementing the ICJ-AO, but there are real barriers on access to justice, especially on having the the legal frameworks and the infrastructure to whereby litigants can actually uh, um, file cases. So, for example, in a lot of jurisdictions, they don't have as much robust rules of procedure that would enable environmental cases to be filed and to prosper. And this includes, lack of um, standing, for instance, in some jurisdictions, the very high levels of standards of causation, as well as magnitude in many jurisdictions, and also attributability as well. So these are cases that are really pertinent to climate cases, and without which there is a regional framework, there is a legal framework or a judicial procedure um, progressive, I would say, in place, it would be very hard for these cases to prosper. So that's on the litigation side, on the litigant side. But there's also the challenge on the courts side as well, and many judiciaries across the region are not as of now as equipped as we'd like it to be on addressing or deciding on climate cases. And there is a need for more, judicial integration of climate considerations, environmental issues, and I think that goes a lot on the capacity of the judiciary to handle and to address the questions brought about by environmental and climate cases. So a lot of this goes also on the judicial capacity within the court. So it's not just the litigants and the communities filing, that also looks at the infrastructure of the judiciary on how they could address that. So overall, it goes down really when we go to other communities and different countries. A lot of people don't know the ICJAO, but there is so much opportunity to use this for their cases. Not just the ICJAO, we also have the International Tribunal for the Law of the Sea advisory opinion within the marine context. We also have other developments as well in other regions that could be used. So it really needs to be a lot more mainstreaming of all these developments to make it, a tool for advocacy and accountability. So that's one quickly. And then the last, maybe I'll just address one question on the influence potentially of the AO, especially on the critical minerals conversation now. It's very important, especially now that there is an opportunity to use the standards of stringent due diligence, but as well as looking at uh, the supply chain due diligence and looking at every stage of the supply chain if there are safeguards in place for human rights as well as environmental due diligence. That would be, the ICJAO can provide the impetus to look at every stage and potentially even make mandatory supply chain due diligence, a legislative standard for many jurisdictions. I know from the supply side, those sourcing critical minerals, especially EV makers, battery makers, sourcing nickel, they have been looking at this as well to ensure that the source of the supply would really comply with the due diligence standards. And it's perhaps important to look at how we can institutionalize this as a mandatory due diligence, supply chain due diligence requirement. And not just that, also the investors could also look at, looking at this. We have, for example, OECD or banks extending loans to investors to look at safeguards in place for every step of the supply chain to ensure that they have safeguards for human rights and environment. So these we can also look at like the ICJAO for the standards that have to be in place for all these things. So yeah, I'll end with those two questions.
Thank you, Rocky. And lastly, BJ, would you like to add?
Sure. Just quickly, I was sitting here thinking that it's almost, I don't know if I should say funny, but that, the question about the Indonesian delegation to COP30, and I'm sitting here thinking, well, at least you guys had a delegation, because I'm from the United States, and my president, in all of his infinite wisdom, has decided not to send a delegation to the COP, and I have the distinct honor of being from the only country that has withdrawn from the Paris Agreement and has initiated the process to withdraw from the UNFCCC. So taking all that into account, my only response would be just to emphasize one of the responses that Safana gave about political will being one of the biggest challenges to putting the AO into action, especially in the United States as the largest, historical emitter of greenhouse gases and, still one of the largest emitters in the world. I think, yeah, that's going to be a big challenge. Hopefully in a couple of years we will overcome it, but we'll see what happens. So yeah, I'll leave it at that.
Thank you, Vijay, and once again, thank you all for all the speakers, for all the insightful presentation. We have now reached the end of today's session. Thank you for joining us today, to all the participants, and don't forget to submit the submission form, the absensi itu apa ya bahasa Inggrisnya? The presence form. And to our four speakers, thank you once again for such a rich and complementary set of presentations. Please allow us to share a few closing remarks. We started with BJ from ILO, who grounded us in practice right away, walking us through 6 cases across 3 continents, already citing the AO in under a year, including Malaysia's Rimba Watch case, the first in our region. The results were mixed, which was itself a useful lesson. How a case is framed matters as much as the legal theory behind it. Further, thank you, Rocky from Ariel, that gave us the bigger regional picture. The AO doesn't create new obligation for ASEAN states. It makes clear that the obligations they've already accepted are now legally binding, not just political promises. That's a real shift for the ASEAN region. Our third speaker, thank you, Zefania from CLCJ FHUI, brought us home to Indonesia specifically and gave us an honest look at where the country stands. Cautious language during the AO proceedings, real gaps in the NDC and emissions trading scheme, but also concrete, unexplored litigation strategies worth pursuing. Lastly, Savannah from ICEL, thank you, that closed us out by showing that putting all of this into practice actually looks like ICEL's work on the climate justice bill, the courtroom challenges, and a clear roadmap heading into COP31 in Antalya. Taken together, today's session moved from global precedent to the regional legal shift to Indonesia's specific reality, to a concrete plan for what comes next. The advisory opinion has given us the standard. The work now is turning into real law, real cases, and real accountability. Thank you again for all our speakers and to all the participants for joining this conversation. I will now hand the session back to our MC. Thank you all.
Thank you very much, Dema, and thank you to all our speakers and panelists for such a rich discussion this afternoon. So bringing it all together, BJ showed us the advisory opinion already in courtrooms with mixed results, proving that framing matters and as much as legal theory. And Rocky brought into ASEAN not new obligations, but real legal consequences for existing ones, from EIAs and to defender protections to the climate bill. And Zefania turned the lens on Indonesia, a gap between our UN vote and our AO stance, with open questions on NDCs, ETS, and fossil fuel reliance. And Safana closed with ICEL 4 tracks and a clear path to COP31. So taken together, today's discussion makes one thing clear. So 1 year after the advisory opinion, the normative momentum is undeniable, but turning that momentum into enforceable domestic obligations, real litigation strategy, and consistent regional positioning is the work that lies ahead and the work this community is already doing. So to our speakers, BJ, Rocky, Zefania, and Savannah, and to Demo for moderating today's discussion, and also to Law, Ariel, and CLCJ as co-organizing partners, and thank you to everyone who joined and engaged so actively this afternoon. Thank you very much.
Thank you.